Good morning. Tuesday, April 11th. We're glad you're here. A nice full house. Hope you're anticipating a good day. This is Criminal Justice Full, and it should be our last committee meeting unless something drastic happens in between. Is Albert Jones in the house by any chance? He's not here yet. I want to introduce him to you when he gets here. Okay, are there any personal orders? Yes, sir. Go right ahead.
Thank you, Mr. Chair. I just wanted to welcome my wife and my auntie in the gallery today. Go ahead and raise your hand there, folks.
Chairman Farmer.
Yeah, thank you, Mr. Chairman. Just wanted to welcome. I see a lot of assistant district attorneys out there and district attorneys and public defenders. Specifically, I have our public defender from the 4th Judicial District. I have Rebecca Lee back there, sitting next to Patrick folks. So if we can make her feel welcome.
Chairman, here's the names of all of them. Go ahead and introduce them.
And I also have three. I have two assistant district attorneys from hometown. Our investigator. I have Jeremy Ball. I have Tracy Ivy, and I have Brownlow Marsh there. So I just want to make them feel welcome as well. They're from the 4th Judicial District as well. And while I'm at it, I was handed a list here. And I'm having the pleasure and opportunity to introduce several others. We have General Brent Cooper from the 22nd Judicial District. We have Ray Whitley. We have General Fennell out of the 9th. Danny Goodman out of the 29th District. We have Karen Burns, Laura Clements, Andrew Hayes. And, of course, we have Jimmy Dunn's office, who I just mentioned, out of the 4th. We have Williamson County District Attorneys here out of the 21st Judicial District. We have Ryan Desmond out of the 5th. And Courtney Lynch out of the 12th. I just want you all to know how much we appreciate what you do. You're in the trenches. You're in the courtrooms defending and pursuing those who have committed crimes here in the state of Tennessee. I want you to know how much we do appreciate and recognize all of your hard work.
Chairman Doggett.
Thank you, Mr. Chairman. Members, each year the Summertown Times will list the top 50 under 60 for district attorney generals. And I'm honored to say that this year my district attorney general from the 22nd Judicial District made that list. Mr. Brent Cooper is here with us today. And yes. And I will say, Mr. Chairman, I had the great honor of working alongside with him while I did serve in law enforcement at the sheriff's office. He was newly elected and has been a great defender and protector of our laws in this state. So thank you very much for being with us and for the work you do.
Chairman Russell.
Thank you, Mr. Chairman. I want to recognize my district attorney, Steve Crump, and his staff. If you'll either wave or thank you for being here.
Okay, also, my intern for this year, Lauren Stanfield, said it right down here. She has worked very, very hard, and she's out of Belmont University and a very bright student. She has been a great deal of help to Grace and to myself. So would you make her welcome and okay, any others? Yes,
Hardaway.
Representative Hardaway. Yeah, sorry.
It's quite all right, sir.
It's hard to recognize you from the back.
I understand. My best side. I want to recognize my DA, General Steve Mulroy, and the work that he's been doing. Unfortunately, he's not here, so we'll recognize him in his absence and the team. As everyone knows, we've got a heck of a atmosphere going on in Memphis and Shelby County, trying to deliver justice for everyone of every age, race, creed, and color. And it's a difficult job. We appreciate the support that we get from Capitol Hill, legislative and administrative. So in his absence, I want to thank you all for the work that you've done to support us in Memphis, Shelby. We need resources, and we'll keep doing the job. Thank you, Mr. Chairman.
Chair Lady Carringer.
Thank you, Chairman. I don't see her in here, but I know she's in the building with her staff and meetings, but I'd like to welcome Knox County's District Attorney, Sharm Allen. Very proud of the work that she does and her staff, and just want them to know that we appreciate all they do in Knox County.
All right. Leader Lambert.
Thank you, Chairman Halsey, and I will say that it is DA Day on the Hill, and if y'all want to show as much love as you possibly can for these folks, encourage our finance team to pass a little bill that'll make sure all these assistant district attorneys get a raise.
All right. Chairlady Moody.
Thank you, Chairman. And I would also like to acknowledge, besides our DAs, and my DA's not here, but Mark Davidson, love you. But we also, this is Tennessee State Employees Day on the Hill, and I know there's some corrections officers in our midst and many other of our state employees, but just would like to say thank you to them and the work that they do, too.
All right, Madam Clerk, will you call a roll, please?
Representatives Campbell, Carringer, Davis, Doggett, Farmer, Fritz, Glenn, Hardaway, Howell, Johnson, Lamberth, Moody, Russell, Towns, Vice Chairman Gillespie, Chairman Halsey.
Here.
Mr. Chairman, you have a quorum.
Thank you. First order of business is House Bill 1029. It has been rolled 3 times, therefore it has to go to the special calendar, so we'll move it to the special calendar and take it up at the end. Next on the calendar is House Bill 0026 by Chairman Faison. We have a motion and a second. Chairman, you're recognized.
Thank you, Mr. Chair, Committee. Very good to be with y'all. After a period of time of incarceration, often when a person gets out of being in prison, they have racked up all sorts of fines and fees. This bill House Bill 26 would make it to where they can appeal to the clerk and get a 6-month reprieve before they have to start paying back their bills, just so hopefully they can get on their feet, hopefully they can get a job, and not have everything hit them at once with their financial responsibilities the day they walk out.
Okay, there's an amendment on your bill. I believe 6346 is what I have.
Yes, sir.
Motion and second on the amendment. We're voting to put the amendment on the bill 6346. All those in favor say aye. Aye. All opposed, no. Ayes have it. 6346. Does that change it, or you want to explain any of that? Or
Writes the bill and does what I just said.
all right. Any questions for the sponsor? Chairman Doggett.
Thank you, Mr. Chairman. While these individuals are incarcerated, is there not any monies that are being taken out of their commissary accounts or what have you to help pay towards fines, fees, restitution?
Go ahead.
Thank you, Mr. Chair. Representative Doggett, that question has not come up to me. From my understanding of friends that I have that are in Department of Corrections penal system, there's not a whole lot of money that they can actually get in that commissary unless somebody from outside sends them to them. It's not like they can accrue much in there unless a family member sent them some money to be able to buy snacks and goods or whatever they need inside the prison. So me personally, I would hope that's not possible because they're doing what they need to do to be able to buy or barter or trade, whatever they're doing there. And that's probably sent to them by their mama or somebody that loves them on the outside. So my thought is when they get out, they're being punished right then. When they get out and all these fines are added up, they need to pay it back, but just let them get on their feet before they pay it back.
Chairman.
Currently, when they are released from incarceration, are these fines and fees all set right on top of them and they have so many days to make this payment, or are they given a grace period currently in law to make those payment arrangements?
Thank you, Mr. Chair. From what I'm understanding is the day you come out of prison, you need to start paying restitution right then. And that's the reason for this bill.
Go ahead. Chairman.
So is restitution included in this language? I didn't think
Sorry.
restitution was.
Go ahead.
Thank you, Mr. Chair. No, I'm sorry, I misspoke. Restitution is not part of this.
Okay, thank you.
Any other question for the sponsor? Yes, Representative Hardaway.
Thank you, Chairman. And I thank the sponsor for the bill. I think the part that keeps the personal responsibility and accountability intact is the fact that there has to be a payment plan before that 180-day delay request is even put forward. Is that correct?
Yes, sir. Thank you, Mr. Chair.
Thank you very much. I think that grace period allows the individual returning to reset, get back on their feet, get some momentum going, and it's not merely when we talk about reentry, it's not merely about how much money you got, but there are a whole lot of things that go into that reentry process, and that 180-day grace period certainly allows, combined with the payment plan, certainly allows all of those support areas to come together and start to move the individual towards a real reentry into society. So I thank you for this.
Any other questions for the sponsor? Yes, sir.
Thank you, Mr. Chair. I just want to go on record saying that this is to postpone for 6 months outstanding court-assessed fines, fees, taxes, or costs arising from the criminal proceeding during the 180-day period. So this is only for that, not restitution. Just want to go on record exactly what this amendment's doing.
All right. Any other questions? All right, we're voting on House Bill 0026. All those in favor say aye. Aye. All opposed, no. The ayes have it. Moves on to finance, sir. That puts us to number 3 on the calendar, which is House Bill 430 by Chairman White. Chairman, you have a motion and a second, and I'm showing an amendment.
7085.
That's what I have. You want to attach it, or you want to wait and explain it?
I believe it does rewrite the bill.
I'm sorry?
It rewrites the bill, correct?
I'm not positive it's your amendment.
It does. It does. It does.
All right, let's put it on there. We're voting. Is there a motion and a second on amendment? Did I hear that? Okay. Now we have a motion and a second. We're voting on amendment 7085. All those in favor say aye. Aye. All opposed, no. Ayes have it. The amendment's on the bill. Proceed, please.
Thank you, Chairman Huxley and committee. If you may bear with me for a few minutes, let me explain the gist behind. And I want to thank Chairman Huxley, Lita Lambert for working with me. We're about in the 10th iteration of this bill. We've been working on it since February. Let me tell you the reason behind it, and it still has challenges, but I don't think the challenges are greater than the issue. I represent Shelby County, and let me give you a few stats. This was several weeks ago, 3,631 cars were stolen in Shelby County since January the 1st. We've had 15,234 cars stolen on an annualized basis. And based on juvenile court figures in 2022, 500 juveniles were charged with serious violent and delinquent acts in Shelby County. These violent crimes are aggravated assaults, carjackings, and aggravated robberies. What's been going on in our community, we're trying to find answers for, and I have never seen it to be so difficult to be able to hold our juveniles accountable for some of the crimes they're committing. If y'all pay attention to the news locally, let me give you an example. Just last week, a lady worked off Germantown Parkway. She went over to McDonald's for lunch. She's sitting in her car enjoying her lunch, and a young man, juvenile, comes up, puts a gun in her face, and takes her car. And this happens over and over and over again, to the point that many of our residents, like my wife included, are afraid to go out to the grocery store because you never know. So there's these issues. We have got to find methods that we hold our juveniles, those under 18, accountable for their actions. give you a few more facts. In Tennessee, juveniles are sentenced to juvenile court, and there is an arbitrary end to jurisdiction on the 19th birthday, which means, and this bill only picks up on 16 and 17-year-olds. But currently, there are only two ways to deal in Tennessee, and I'm here with my DA, so if I say anything that you agree with, then you come to me afterwards. But if you have a violent crime committed by a juvenile, you can either send them to adult court, adult prison, or they go into juvenile detention, but at 19 they walk scot-free, expunged, even if they have murdered a person. And so, in the statistics I have, I was told that only about 1% of those 500 violent crimes go to adult court. So the other 99% are not. What we're looking for is answers on how we can look at our juvenile laws to help protect all the citizens. To help meet the challenge of serious juvenile crime, we need to remove the arbitrary age limit and create an extended jurisdiction in appropriate cases. And I know this is where we are challenged. This bill says when a juvenile is 16 years old or older and has committed multiple serious felonies they are designated as a serious youthful offender. A youthful offender will receive 2 sentences. A juvenile is sentenced to be served. We aren't changing anything about current juvenile law. That stays the same. And they are in that to the 19th birthday. What we're trying to get at in this part is that at the same time they would receive an adult sentence up to their 24th birthday, depending on the type of crime, whether it's an A, B, or C felony. So a juvenile sentence will be what is currently available in the juvenile court. The adult sentence beyond the offender's 19th birthday would include the following minimum times: 4 years for a Class A felony, 3 years for a Class B, and 2 years for a Class C. The adult sentence can be stayed during a hearing within 4 months of the offender's 19th birthday if they have not committed other crimes, or they have engaged in conduct that creates a substantial safety risk. That's another factor. If they have failed to meet conditions of supervision, or if they have gone ahead and finished high school with passing grades, or they have been engaged in activities which are beneficial to the community. The system can then take these into consideration, whether once they hit 19, they either remain incarcerated into the detention system, or they go free. Any sentence after the offender's 19th birthday may include a period of confinement, probation, or a combination. And so that is what we're trying to get at. We've been working with our current DA, Mulroy in Memphis. We have left it permissive for the DAs at this point. He has helped us draft this, as well as our former DA in Shelby County from years past. And so we're trying to find answers. I know the questions I may get as far as, the jury court and things like that. But I think we're at a point in time we had to find answers. The issues are greater than the challenges that we face. We was watching a news article this past weekend in Ocala, Florida, and I saw the sheriff, I think his name was Billy Woods. They had 3 juveniles kill 3 other juveniles. The youngest juvenile was 12. Juvenile crime is different than it was a number of years ago. The sheriff, Billy Woods, said, we have got to find a system to hold juveniles accountable, and we've got to fix that in the law. Now, with that in mind, this is what this bill does. It is in the Senate, ready to go to finance. We know we have some challenges still, as has been brought up to me. So this is what we're trying to do. We've got to find answers. We cannot continue to let our communities be destroyed by those who choose to put all of our citizens at risk. Thank you, Mr. Chairman.
Okay, thank you, Chairman. First on the list is Leader Lamberth.
Chairman, I know you've worked hard on this, and I appreciate it. I have some reservations, obviously, about keeping a child under juvenile court jurisdiction all the way till 24, because they've been an adult for 6 years at that point. But I know where you're headed here, and I have thought for years that the process in our juvenile court system, where a judge has to make the determination really at the beginning, at the request of one of our district attorneys at the beginning of that case, is probably not the best time period to do that. I mean, my preference would be to make that determination on transfer after they've been in juvenile court. Now, that gets really hairy from a process standpoint, from a constitutional standpoint. I mean, it's a very difficult thing to say, well, look, we're going to delay making a determination to transfer to criminal court. And I know you've tried to kind of fit both worlds together on this, but my biggest worry is that it will give an out, really, on not transferring to adult court on some of these really serious crimes that really do need to be transferred. And so for me, it's not quite there yet, and I'm just one voice, but I did want to ask about, I think it's subsection F on the amendment. It says that the courts shall make an audio recording of all of these proceedings. Is there it was just a little thing, but I wanted to ask, is there a concern that that's not happening in juvenile courts? Is there a reason why that was important to put in this? Is it a restatement of current law in any way? I just kind of noticed it in the amendment. I was curious what that was in there for.
Yeah, on page 3, section F, I read that. That was when we had one more iteration that was put on in the Senate, and I couldn't give you the reason why because I don't have the background on that, but that was put on then.
All right. Thank you, Chairman. I just, I know you've done a lot of work on this. I feel like there's probably a little more to do, but it keeps getting closer every time. You put an enormous amount of work on it, and I appreciate the fact that you are an absolute phenomenal advocate for your district, and you guys are trying to solve some very difficult problems down there. So thank you for your hard work on this.
Vice Chair Gillespie.
Thank you, Mr. Chair. Chairman White, I worked with you on this a bit, and our districts touch each other, and I just want to echo some of the stuff that you said about the public safety situation in Memphis in regards to juveniles committing crimes that really juveniles used to not commit. So this is the outside of the box thinking that I think we need. There's definitely much more work that we need to do, but I'm 100% supportive, and I firmly believe that this will make our area safer. I can't tell you how often I tell friends, family members, my mom, everyone, I'll go get gas for you. I'll go get groceries for you. I'll send Instacart. That's not a way to live life. So thank you.
Yes.
Thank you, and thank you for those comments. Remind me of one more thing. The reason we're trying, we have got to find answers currently, for the 16 and 17-year-olds that can do this. I'm a big believer that our gang members down there know this very well, that you can't do anything to a juvenile, so you get a 14 or 15-year-old to do your business. You get a 16-year-old because they're going to go free at 19 or at all. And most of them, give you a concrete example. We had a really fine lady. She was a minister down in our community this past fall. The young man, a young man who was a juvenile, came in her driveway, carjacked her, shot and killed her. He had already been arrested. He was wearing an ankle bracelet. So these kids are put right back out on the street with nothing more than an ankle bracelet. How is that going to change anything? We have got to detain them or detain them longer, or we're going to continue to go down this road.
Thank you, Representative Johnson.
Thank you, Mr. Chairman. And thank you to the sponsor for this bill. I do understand and appreciate what you're trying to do. And we have got to keep our communities safe, absolutely. You said that juvenile crime that juvenile crime is different today, but I have to say that juveniles are not different. And so what we're seeing is a group of folks under stress, in underserved communities that don't have the resources they need. And I think that we have to also consider preventative. And that's for another day, of course. But I think that we sometimes focus too much on punishment and not the prevention of these things. So I understand what you're trying to do, and I think that it is important. But I am concerned that juveniles are still the same as they were then, and we have got to get them the services that they need so that we're not seeing this. But I do appreciate the concerns that you feel, and again, this is something. There's going to be less violent crime if we can do something, perhaps as far as gun legislation in the future.
Chairman.
Thank you, and I don't disagree with you. I appreciate those comments. You're right. But at some point, we have to hold people responsible for their actions. To have an innocent victim also lose their ability to have their freedom of life, their freedom of going out and enjoying quality of life. We've got to put it, I think it's very unfortunate. I'm a big believer that a lot of reason juveniles are different, they haven't had a background in a home that gave them any kind of direction, and that's sad. But that doesn't negate the responsibility we have to punish so that we can protect all of our citizens.
Yes, and I do believe in consequences for those crimes, absolutely. But I would rather prevent it before there are victims and before the crime is committed.
Chairman Doggett.
Thank you, Mr. Chairman. To the sponsor, thank you for your quest to find solutions. I echo a lot of the same concerns that my colleague from Sumner County has. I'm just not really comfortable where we're at this point going forward, but I would ask, would you be agreeable to roll this bill to a calendar next year to give more time to sit down with others to really dive deep and look and see if we can find a very good, amenable solution to help address this issue?
Chairman.
To answer your questions, I do not want to lose this in committee. If it's the will of the committee that it would not move out, because we need to continue to work on this next year. Our policy and rule is if a bill dies in committee, I can't bring it back to the 114th session. So I certainly don't want to go down there. If this committee feels like we need to keep working on this, and believe me, we have put a lot of work on this, trying to get all the parties working with the DAs and legal and all that. But I will bow to the wishes of this committee because I do not want the bill to die. I want to be able to, we can keep working on this. But I do want to send a strong message, not across Tennessee, but in Shelby County, that we have got to find an answer. What's going on is not acceptable.
Representative Davis.
Thank you, Mr. Chairman. I just wanted to kind of ask you, it's probably a rhetorical question, but punishment is meant to be a deterrent, is it not? And stiff punishment is meant to really help strongly encourage that no one commits that crime. And that's kind of the point of prison sentences, wouldn't you say?
Punishment, when that switch hit my legs growing up, that was punishment, and that deterred me, yes.
Chairman Doggett.
Thank you, Mr. Chairman. I would make a motion that we roll this bill to the first calendar of 2024.
Second.
There's a motion and a second to roll this to the first calendar of 2024. Any objection? Representative Hardaway.
Thank you, Chairman, and thank you, sponsor, for the bill. Chairman, I think at some point we've got to get in the mode that we're going to do some work that's going to reflect the needs in the community. Our children right now are being forced into a system where it's either or. You're either going to be an adult as determined by an arbitrary and capricious age of 18, has nothing to do with biology. It has nothing to do with the capacity for the young person to actually absorb the information, absorb the deterrence that we think we're building into our criminal code. At that age, anytime the science says, we're not guessing at it, the science says that up until 25-ish, these young folk can't control their impulses. They do stupid stuff. Why? Because they can't control their impulses. Why is that? Because their brains have not fully matured. The longer we wait, that's not going to change. That's not going to change if we wait until 20, 24, 25, 26, or 34. That science is certain. Our obligation right now is to do what we can do. I would suggest to my colleagues that if we go ahead and pass this, start working the language that we have as is, and we can come back and tweak it as necessary. There's no perfection in criminal code. If I haven't learned anything else since I've been up here, Mr. Chairman, I've learned we don't turn out perfect bills, much less in criminal code. But I will tell you that the young folks and potential victims of juvenile crime and crimes from young adults, it's going to get worse. It's definitely going to happen if we don't make a move today and send the bill that Representative White has, which helps us to get some momentum in juvenile justice reform and in the adult criminal justice system. He didn't go through all the statistics which suggest to us that what we're doing right now is not working. When it doesn't work, people get hurt, people die. He cited a couple of the more notable cases where the victims were noted members of the community. So I would say to you that we have an obligation to our community to pass this bill out of committee. We can continue to do work on it, even moving to the next committee, but we need to have something different from what we have now. Juvenile crime is rampant. What we're doing is not working. Another year's worth of juvenile crime rising, another year worth of juvenile crime victims rising. That's not what our community wants. That's not what they deserve. They demand that we do something now. So I would ask, Mr. Chairman, that we not, and ask my colleagues to vote not to put this bill off, but to give it a fair shot at being in practice for at least a year, and then we can come back and revisit it. So I would say no, do not put this bill off. Do not put it off, because people will die. We will have juveniles whose lives will be ruined because we did not have the proper juvenile justice system and adult justice system called blended sentencing that can help them. Thank you, sir.
Okay, go ahead.
I was going to say what he said.
Okay.
He said it much better than I.
All right, can I just interrupt here in a train of thought? Albert, is that you back there? Will you raise your hand? That's Albert Jones. That's my cousin right there, and his two daughters right back over there. He came all the way in from Alaska to watch this, so I have not seen him in a long time. Welcome, brother. I'm glad you're here. All right, back on the topic. I'm sorry, Vice Chair Gillespie.
Thank you so much, Chairman. It's not often that I'm going to so heavily agree with my colleague from across the aisle from Shelby County, but I do believe that this legislation is too important for us to wait another year for. We do have people that are dying in my community on a daily basis. We have moms that are being robbed at gunpoint on a daily basis. We have children that are not living their full potential on a daily basis. And if this committee does not act, that will be another year where hundreds of thousands of citizens of the state of Tennessee will be adversely affected. And I personally do not want that on my conscience. I don't want to sound drastic, but it is very, very drastic of what we're talking about. So I strongly recommend that we take action on this today. Thank you so much.
Chairman Farmer.
Yeah, thank you, Mr. Chair. And I just want to just concur with the motion to roll it to 24. And here's why. In my 10-plus years of being here, every time we've moved something out of committee almost every time, we've always had to come back and fix it. So I think anytime we pass legislation and we discuss policy and change the law, which is one of the most important things we can do, we need to be thoughtful. We don't need to just be passing it just because of, hey, there's certain issues in certain areas of the state. We need to make, this is a law of general application. General application, that means it applies statewide. So we need to make sure that it's in the best interest of all of our constituents across the state of Tennessee. And that's why if we need to take some more time, look at it, think about it, get it right first, it's something, instead of something being wrong with it, unconstitutional with it, or X, Y, and Z, then so be it. So for those reasons, I concur, and I think, and I commend the sponsor for bringing this piece of legislation. I think it's a good piece of legislation, but just from what I've heard today, and not being appointed to the subcommittee, I didn't get the opportunity to speak to you in subcommittee about it, but I do agree. Let's move this down to 24. Let's think about it. Let's make sure we have a good piece of legislation, good policy on sound constitutional grounds that's going to work and that we're not going to have to come back and fix. So with that said, Mr. Chairman, I appreciate the opportunity to give me an opportunity to talk. Thanks.
Representative Hardaway.
Thank you, Mr. Chairman. I'll remind my colleagues that we've been talking about this for years, literally years. We've had work that was done on blended sentencing when in my county we had a DA from across the aisle. The DA that's there now is of the other party, my party, and the only thing, as Chairman Gillespie said, that we've been able to agree on is that what we're doing is not working. It hasn't been working for years. We've been working on this for years. People have been dying for years because of juvenile crime, and juveniles and young adults have had their lives derailed for years. So the work that we put in over the past few years, not just myself, not just Chairman White and Chairman Gillespie, but DAs from all over the state, juvenile court judges from all over the state, other stakeholders from nonprofit groups from all over the great state of Tennessee have put work into this. This is not my preferred language, but it's the best language we can get right now. And that's what I suggest that we go forward, with all due respect to my colleagues who are hesitant, that we go forward on this because we can't afford to wait because our community can't afford for us to wait. Juvenile crime has been going up exponentially every year. Do we want another year of juvenile crime growing exponentially out of control in Tennessee? And we have missed the opportunity to do something about it. I said no. I say we need to pass Chairman White's bill, and we need to do whatever we need to do to bring the right resources to the table to make it work. The professionals, most of the professionals have said, yeah, we've got to do something. This isn't perfect, but it certainly gets us a good running start at it. And there's no better way to tweak it and make it perfect than to have it active in the community. So let's please don't let the perfect be the enemy of the good in this instance. Thank you, Mr. Chairman.
Chairman Howe.
Thank you, Mr. Chairman. I concur with Chairman Farmer. I've been here 9 years, and when I came in as a freshman, one of the things that has stuck with me is something that a former colleague of ours who had been in this body for about 25 years said on the floor. We were debating a bill, and he said, it was a similar situation. He said, sometimes to go fast, you got to go slow. And in my 9 years here, I've found that to be true. If you go fast, you tend to make mistakes, and you have to come back the next year or 2 years and correct the mistake that you made. I guess I have a question for the sponsor. What's the status in the Senate, Chairman?
Go ahead.
It has passed totally out of the Justice Committees over there. It's sitting in Finance.
Okay. Mr. Chairman. Has it been calendared on the floor yet?
It has not, has it been calendared? I don't know. Don't know the answer to that.
Okay, Mr. Chairman. What is the effective date?
This act takes effect July 1, 2023, the public welfare requirement, so July.
Okay, July 1st, so 6 months until our next session. As much as I sympathize, and we were just having the conversation here, we have to do something. But I just want to make sure we do what we need to do, not have to come back and correct it. So I would concur, Mr. Chairman. Thank you.
Vice Chair Gillespie.
Thank you, Mr. Chair. I do want to remind everyone, too, that at least in Shelby County, I would imagine other places with similar climates are the same. Summer is the highest time of year when juveniles are committing crimes, and we're about to be in summer. So I do want to make that point clear, and that I, again, strongly oppose tabling this to next year, because people are dying. People are going to continue to die. And I have some great moral reprehensions about that. And I think this will fix. It's not perfect, but it will help the problem. And that's it. Thank you.
Chairman, if you have a reply.
Thank you, Reverend Hardaway, for those words, Gillespie. Yeah, I'm torn. Like I say, I'm looking at the committee. I'm at the will of the committee, because we definitely don't want to lose this bill. We need to move forward with it. When we say time, we really run out of time in many ways. Personally, I don't see the damage if you pass the bill. And as we go forward, it may get into the court system and challenge, but at the same time, we've got something on the books that we can work and challenge. The challenges are still there, but like Representative Gillespie says, this summer, ever since the COVID, we have approximately 100,000 students in our Shelby County school system. I am told, and I don't have the figures to back this up, that as many as 20,000 are not there on any given day. A lot have not come back. These older juveniles, the gangs have got them. They're turning into criminals. They're preying on the innocent in our community. And I just think that we need to send a message that, we've got to stop this. And as we move forward, if it's challenged, and we can keep working on it come January. But there again, I'm at the total will of this committee to make sure we move forward and we're not slowed down any.
Leader Lamberth.
Thank you, Chairman. And I know this committee, a lot of folks don't like coming in front of, because we have very spirited debates in here, because it's life or death on any bill we are debating. That's what criminal justice is here for. I've been honored to serve on this committee for 11 years. In most jurisdictions in this state, when a juvenile commits a violent crime, they are probably going to be transferred to adult court. If we're going to talk about dangerous, treating a 24-year-old like they are a child is dangerous. So in most jurisdictions in this state, again, a 16, 17-year-old child who commits a very violent crime, the juvenile judge is going to look at that circumstance, and most district attorneys, again, we're talking for high-level violent crimes, they're going to transfer that individual to adult court where they can be supervised for a very lengthy period of time. Doesn't mean they have to go to prison, doesn't mean they don't get services, but they're transferred to adult court. So I think we need to be careful about how we talk about this particular bill, because if you have a district attorney in this state that is choosing not to transfer dangerous juveniles, that doesn't change everything throughout the rest of the state. And we have a lot of DAs in the room today, and I commend all of them from Mountain City to Memphis for the job that they do. But we're trying to fix a localized problem, it sounds like to me, with a statewide solution. And I have a serious objection to treating a 24-year-old like they are a child. That is a grown adult person, and they should be treated as such by the time they hit 24 years of age. And we can talk about the fact that they're still maturing. We can talk about the fact that they have impulse issues and everything else. I get it, but they're an adult. At some point, we have to draw a line in the sand. Thank you.
Yes, sir.
Yeah, thank you, Chairman. Very, very well said. The reason that being is currently, though, with a 16, 17-year-old commits a violent crime in Tennessee, they're free at 19. So that was the understanding, if not. And the figures that I were given, have been given, is a very small percentage of those who commit violent crimes do go on to adult court.
Go ahead.
If I may, again, they are free at 19 if they were not transferred to adult court for supervision there. So again, if you have in your system judges or district attorneys that are refusing to transfer violent criminals to adult court to be supervised there or adjudicated there, that is a localized problem that the people of that district need to address their elected officials in. For the rest of the state, I'm not hearing that type of issue. I trust my juvenile judges. I trust my local district attorney to make those decisions. But yes, if they leave someone who's committed a very violent crime in juvenile court, I can see where that creates an issue. But those are just my thoughts.
Representative Johnson.
Thank you, Mr. Chairman. And though I'm not 100% on board with this bill, we pass bills all the time in here that we tweak yearly. When we see problems, we tweak them. And I think we need to think about that. We pass bills often that we know are unconstitutional. I think it's really important that we look at potential solutions, and we can always tweak as we go along, with we do with so many other types of legislation. And we know that the research bears it out that enhanced punishments, we definitely need to hold people accountable for crimes, but when we are enhancing and moving over to adult court, there is no data that shows that these enhanced punishments are any sort of deterrent.
Representative Hardaway.
Thank you, Chairman. And we have to be careful with our terminology. This bill is not about having a 20-year-old child. It's about understanding the science that tracks the development of adults. And it says that you don't have the full capacity of a mature adult brain until you're 25-ish. We're not making that up. That's what science says. And guess who knew it before we said it? The rental car companies, insurance. They didn't want to see, and some still don't want to see, anybody under 25 putting their product at risk. There's a reason for that. They've known this for decades, scores of years, that if you're 25 or older, you're of a least risk to have an accident, and the severity of the accident is not as severe if you're 25 or older. That's data. They've had it for decades, for scores of years, and it's worked for them because there's no system that sorts this out better than capitalism. And that's what's worked for them. But I'll also remind my colleagues that 13 in some countries is an adult. That doesn't make it right. That just makes it what society has determined is going to be the order in that particular society. Sometimes it's 18. We also have laws which give you different legal freedoms depending on age. 18, you can do something. 21, you can do something. So let's look at the science. That's what we're talking about. Taking an objective look at data that's been verified time and time again. There's scholarly works on this that tells us that we need to do something differently if we're going to stop the rise in juvenile crime, if we're going to prevent murders by juveniles, if we're going to prevent shootings, violent acts, carjackings by young folk. I'm not calling them children. I'm saying young adults have not smaller versions of mature adult brains. They have undeveloped versions of adult brains. They're not, 13-year-old doesn't have a little adult brain in him. He's got he or she has an undeveloped version. So I would ask that we stand back, look at this. This is our chance to make a difference in the community. This is our chance not to see those headlines, and those headlines include somebody we know that's been murdered or carjacked or shot by a juvenile, whether it's another juvenile or an adult or an individual. Some of you may recall, Mr. Chairman, that I have a bill that, and I'll bring it back in 2024, dealing with community terrorism. The majority of that is done by young folk, by young adults and juveniles who are currently referred to as juveniles. So there are things that they will do today. There are things that they will do tomorrow, next week, next month, next year, that will result in deaths, result in harm to members of all of our communities. And we have an obligation now to make a difference by passing this legislation that Chairman White has that will start us on the road to doing the right thing for victims and doing the right thing for those young folks who can receive rehabilitation. Let's keep in mind that the experts, the professionals who work with young folks, the priority is rehab, to rehabilitate those young folks, because they've still got room to grow and develop. The deterrence that we heard cited earlier, that's aimed at adults. It's deterrence and, in some cases, equal rehab that we have in store for them. So let's not mix those up. The science says we got to do something different. Please, let's do something different today. Thank you, Mr. Chairman.
Okay, Chairman Doggett.
Thank you, Mr. Chairman. It is obvious that there are members of this committee that are passionate and have shared their plea on both sides. I know that we work diligently through the subcommittee process as well as the full committee process on every piece of legislation that comes through. The first time that we read these bills are not when we come and sit at the dais. It's when we begin our preparation 3, 4, 5 days before, when the committee calendars are published on those Wednesdays. A lot of hours go into time, a lot of time that we spend reading the language of these bills. We look at what they do in the TCA code. What we do in the criminal world is extremely important because it affects every Tennessean, from criminals to victims, family members, prosecutors, judges, law enforcement officers. Everyone, every Tennessean is encapsulated within these bills, these laws that we pass. And so it is extremely important when we have legislation before us that we make sure that every T is crossed, every I is dotted. And I think we do an excellent job in these committees. There are other committees that we have that I have the pleasure of serving on that sometimes we do see things, we may not see things as clearly, and we might make some minor mistakes here and there. Things that might affect commerce or health care, and we come back and make those corrections. But when it comes to the criminal justice world, if we are to make a mistake, it's an entire year before we can come back and rectify those issues. We're talking about changing the lives of millions of Tennesseans by some simple oversight that we have because we want to pass something on a whim. We want to pass something because we feel like it might be something that is great for our community. I admire the sponsor for his work. I admire every member of this committee for their work. I'm extremely grateful and appreciative of everything that's been done in these committees. I made a motion earlier to move this to the first calendar of 24 so that we could continue to have these conversations, so that we could get other actors, other people in our community that are involved in these decisions, from the enforcement to the carrying out of these orders, to those that are tending to these juveniles. We've heard things about data. We've heard things about science. Not every member of this committee has been privy to this information. And by giving us more time to work on this, we can explore these other avenues. We may come back to the same place that we are now. We may have found a better solution by the end of this time. But members, I think it's very important that we consider what we're doing. If we were to move forward, what are we putting at risk? And so I'm going to renew my motion to roll this to the first calendar of 24. Thank you, Mr. Chairman.
Okay, the motion still stands. Chair Lady Carringer.
Thank you, Chairman. And I think there's no doubt that everyone that sits on this committee is very passionate about our children, and we want to make sure that we are doing the right thing. And I look at the bill, and there's not been anything really said about this bill. I respect my Knox County Juvenile Court judge. He knows what he's doing. He knows what he's talking about. And I would really love to be able to sit down and talk to him to see exactly about going forward with this bill, to find out what we need to do and what we don't need to do. And I am concerned that, does this bill allow for these defendants to have a jury?
Thank you. That is the entire debate. Some legal counsel says you don't need it because it's juvenile court sentencing. Others say that is. I've had this conversation with Chairman Halsey. That is one of the things where we had to work out continually.
Go ahead.
So I think I just got my answer because I was watching before down here. So I think this is a very important bill, and I'm not going to continue to tie up. I would like to see it move on, but I'm not going to put you to a vote right now because I know it's tough. So, and I appreciate Representative Hardaway so much. You're exactly right. Your comments. See, we do work well together, folks. So, thank you very much for your kind comments. But I'm reading the room right now, and I really want this to pass. But if y'all feel that you want to speak to your DAs and things, and I'm kind of counting the votes right now, I will move this to the first calendar of next year.
Okay, Chairman, you're welcome to call the question. I appreciate that.
Great. Yeah. I made the motion, so.
You can't call the question. I'm just.
Can I vote?
I'm just dragging you.
Chairman, I did have the reason why I asked that is because if you don't, how can we just sit and hope people for years? And that, without something. So I'm very passionate, and I'm very thankful that you brought this to us, and obviously we all feel the same way. So I want to make sure that we get it right, and I appreciate you for that. For that. So
yeah, thank you. In committee, thank y'all very much. I appreciate your time and the discussion. Very, very good. And we've got to get there, but thank you.
Mr. Chairman.
Chair Lady Moody.
Thank you so much, and thank you, sponsor. And members, I'm reminded of, we had an ad hoc committee that worked diligently this summer on these juvenile issues too. And I don't know if you had a chance. I see Chair Lady Littleton. She was our House Chair of that ad hoc committee. So I would love for us to be able to piggyback on all they went on tours, they went on locations, and I'd love for us to be able to learn from their hard work and many, many months that they spent on this issue too. So I just throw that out there as another resource for us. And yes, we need to
Thank
fix
you.
it.
Thank you very much. Thank you, Chairman, Committee. Appreciate this discussion.
Parliamentary, Mr. Chairman.
Based on what the sponsor of the bill has said, to move this to calendar 2024, Representative Hardaway, go ahead.
Thank you, Chairman. Just want to make sure about the posture would place the bill in that won't put it in danger of going to the clerk's desk, will it?
No, this will be rolled to the first calendar of 2024. It won't get lost. So that's why we can't summer study it anymore, is because the bill dies when we do that. So that's the process now. Leader Lambert.
Mr. Chairman, I know we're having a spirited debate, and it's a good one, but I noticed a couple of folks walked into the room, and I know we've all bragged on our district attorneys today, but there's only one district, the 18th Judicial District, that has the longest-serving district attorney in this state, and quite frankly, in my humble opinion, one of the finest gentlemen to ever serve in that regard. And General Ray Whitley has joined us, General Eric Malden, one of his assistants, and General Tara Wiley. If y'all can, rise and be recognized. And my former boss, I might say, Chairman. So he literally taught me everything I knew. I forgot half of it and have tried to regain it. So
maybe you ought to sit down with him again. That would help. All right. Without objection, we're moving this to the first calendar of 2024. Thank you, Chairman.
Thank you, Committee. Much appreciated.
While we're between bills, my cousin Albert back there, if you can stand it to wait long enough, I will take you to lunch after this is over, but I'm not positive how long it's going to last. That brings us to item number 4, House Bill 472 by Chairman Crawford. There's a motion and a second. Chairman Crawford, you're recognized. Yes, we do. 5579, is that what you show?
That is correct.
All right, we have a motion and a second on the amendment. All those in favor say aye.
Aye.
All opposed, no. The ayes have it. Amendment 5579 goes on the bill. Please continue.
Thank you, Mr. Chairman. Thank you, committee. This bill provides a common sense definition of adequate shelter for a dog so that the law can be applied equally across the state. It does not apply to any other species, including livestock or working animals.
All right, any questions for the sponsor?
Question on bill.
Question been called on the bill, House Bill 472. We're voting. All those in favor say aye.
Aye.
All opposed, no. Ayes have it. Moves on to finance.
Thank you.
It brings us to item number 5, House Bill 1106 by Chair Lady Littleton. Motion. You have a motion and a second. Chair Lady, I don't see any amendments.
Oh.
All right, you're recognized.
Could I have a personal privilege, please? For
Indeed.
1 second. My DA is here, too, and I consider him the best one in the state of Tennessee. He's been through some terrible things these past few years, and he's walked us through them and done a wonderful job. Ray Crouch. Thank you, Mr. Chairman. House Bill 1106 authorizes the juvenile court to transfer a child who is 16 years of age or older to an adult criminal court for committing the offense of escape from a youth detention center.
All right, you've heard an explanation of the bill. Any questions for the sponsor? Representative Johnson.
Thank you, Mr. Chairman. Would this include, say, someone who was in DCS custody sleeping in one of the offices or wherever they are taking them now? Would this include one of those teenagers that just walks away from that facility? Would that be considered escaping?
Go ahead.
This would be those confined to a youth developmental center.
It says...
Number 2 says confined in a youth developmental center, approved and certified and licensed.
Representative Johnson.
Okay, I still have some concerns about that language, but thank you.
Any other questions for the sponsor? All right, without objection, we're voting on House Bill 1106. All those in favor say aye. Aye. All opposed, no. The ayes have it. Moves on to calendar and rules.
Thank you, Mr. Chairman and committee.
Moves us to item number 6 on the calendar, House Bill 381 by Leader Beck. Is there a motion? And a second? Leader, you're recognized.
Thank you, Mr. Chairman and committee. This bill adds a new sentencing enhancement factor for any offense where the defendant is an adult and committed the offense with a minor, regardless of whether the minor is convicted of the offense or not. In several of our larger cities, we've got adults who are getting minors to break into cars at night, and so many other schemes, carjacking, et cetera. And so this will give the judge the ability to give an enhanced sentencing to the adult if he is taking these juveniles and forming these task gangs, or however you want to put it, to go around and commit crimes. And with that, Mr. Chairman, I stand to take answers. Questions?
All right, you've heard the explanation of the bill. Any questions? Representative Hardaway.
Thank you, Chairman. Is this the Oliver Twist Act, sir?
You could look at it that way, Representative Hardaway.
All right. Any other questions for the sponsor? All right, we're voting on House Bill 381. All those in favor say aye. Aye. All opposed, no. The ayes have it. Sir, moves on to finance.
Thank you, Mr. Chair and committee. Have a great day.
Congratulations on a successful bill in this committee.
Thank you, sir.
That brings us to item number 7, House Bill 22 by Representative Chisholm. You have a motion? You got a second? I don't see any amendments. Representative Chisholm, you're recognized.
Thank you, Mr. Chairman and committee. Okay, so I've brought to you House Bill 22, and this bill requires law enforcement to initiate a audiovisual recording for a interrogation of a minor. This bill is currently, most departments statewide at all levels require these recordings to be done as part of their department policy, but it makes accountability circumstantial. Passing this bill would protect both the children and police in the same way body cameras do. The only concern brought to light on this bill is that passing this bill could trigger the exclusionary rule in some cases. What that means is, in some cases, if police were to fail to record an interrogation and they get a confession from a child, that confession could be inadmissible under the exclusionary rule. However, this bill allows honest mistakes in the language. It states that an officer must reasonably believe that he or she is recording and allows for extenuating circumstances which are broad in law. In other words, it would almost have to be a situation where it was an intentional act to interrogate a child without recording to trigger the exclusionary rule. So, this bill has already passed in the Senate unanimously. The sponsors of the bill, we've worked with groups such as TBI, the Tennessee Sheriff's Association, the Tennessee Association of Chiefs and Police, to help craft this legislation. And with that, I ask you for your consideration.
Okay, one point. An exclusionary rule, if it's violated, it doesn't just, you don't just lose the confession, you lose all the evidence that comes after that as well. That's also tainted. All right, Leader Lambert.
Thank you, Mr. Chairman, and I've talked to the sponsor before this and have enormous respect for him. But I do still have concerns about that. I think you've tried to make sure that if it's a technical glitch or exigent circumstances that it covers it. But most departments are already doing this under their policies and procedures. It's a good idea to do this. I want those confessions to be recorded. But if for any reason that there's ample evidence that, you know, a judge or a jury can take into account issues where a recording was not made, but to require it in law, I just don't want someone who makes a full confession that possibly commits a horrible crime to go free just because something wasn't recorded. If there's an officer that's willing to testify to it and they're willing to swear under oath, and sometimes maybe multiple officers or other witnesses to the fact that a confession was made, I just don't want to get into a position in society where we have to record every single thing that happens in order for us to believe it. I think that can be handled in court through cross-examination. I think that can be handled through other ways. So I would make a motion at this time to send this to a summer study. We had, and I mean a legitimate summer study. We had another bill by another representative out of Rutherford County that was similar to this, that dealt with parental notification if a child is in custody, that dealt with some of the policies and procedures. And I actually think the combination of y'all's two bills, there's something there. I mean, there's more we can do, I think, to, you know, make sure that the policies and procedures at departments do include this. But to put it in the law, even with a couple of exceptions, I just don't want someone to go free that has committed a horrendous crime just because it wasn't recorded in the confession. And I agree with the chairman. It would be fruit of the poisonous tree, I think, at least in most courts, if for some reason that confession's tainted and then it led to other evidence and then they got us. I mean, it just kind of sets off a chain of events when the confession may be 100% legitimate. I just hate to set that up. So, Mr. Chairman, I would make that motion for a summer study at this time, and I would ask, Mr. Chairman, if you don't mind requesting of the Speaker both this topic, the other one that the other representative had, and quite frankly, a couple of these juvenile justice issues. I would very much like, Mr. Chairman, if we can get together over the summer to really have a day or two to allow this member to come in and bring in multiple witnesses, bring in multiple individuals that can tell us about some of this technology and really spend some time on some of these bills dealing with juvenile justice. That's my motion, Mr. Chairman.
There's a motion. Is there a second? There's a second. Do you have any response to that, sponsor?
I'm at the will of the body.
Okay, there is a motion and a second to move this to summer study. All those in favor say aye. Aye. All opposed, no. No. The ayes have it. Moves to summer study. Thank you, sir.
Thank you, Chairman Committee, and I look forward to dialogue over the summer.
I will to speak to the Speaker about setting that up this summer. All right, that brings us to number 8 on the calendar, House Bill 1444 by Leader Lamberth. Leader, I'm showing I need a motion and a second. Motion. And a second, and I'm showing one amendment.
Yes, sir, Mr. Chairman. It should be coded 7341.
7341 is what I'm showing. Need a motion and a second on the amendment. Motion on the amendment. Is there a second from the left side of the table? Okay, I heard it now. We're voting on Amendment 7341. All those in favor say aye.
Aye.
All opposed, no. 7341's on the bill. You're recognized, Leader.
Thank you, Mr. Chairman. The bill does 3 different things. It deals with kind of a quirk in the law where non-commercial vehicles can be kind of spewing things down the roadway like, you know, rocks, materials that are falling out of their truck. And for commercial vehicles, that's a low-level misdemeanor citation. For non-commercial vehicles, unfortunately, it's not. So this would create a C misdemeanor for that. It also fixes something that I didn't know was in the law until we were dealing with the BUI statute earlier in the year. And under boating under the influence, when we made that marry up with DUI law, there's apparently a quirk where just one county in the state could do 200 hours of community service instead of 48 hours in jail on a DUI. That was from the DUI statute. So the second portion of this takes that out and makes it where the DUI punishment, if somebody is convicted of a DUI first offense, is consistent throughout the state. There's no one county that should be special that's treated any differently, where if you get a DUI there, it's less of a penalty than somewhere else. And then the last section of this deals with vehicular homicide, where someone leaves the scene of an accident. If they're convicted of that, it will make it 100% sentencing and make it in line with our other truth in sentencing laws. Mr. Chairman, that's what the bill does, and I stand ready for questions.
All right, you've heard an explanation of the bill. Any questions for the sponsor? Representative Johnson.
Thank you, Mr. Chairman. I just want to clarify something. So, could a measure like this ultimately result in an unfunded mandate for local jails?
Go ahead.
No, we provide funds for anything that has a local fiscal note. This has a very low local fiscal note on it. and I believe it's $2,212. So we do provide money for that, and constitutionally we have to. It's literally one county, and it obviously is their call on how to deal with that, but you can't just have one county where you don't serve 48 hours. And in talking to some folks in that county, I actually don't even think they're using this because they're not going to want to look like penalties lighter for DUI in one county than any other county. That's a pretty bad look for the public. And so we have built into this a $2,212 fiscal notes. I've got to go to finance next to make sure that it's not unfunded. But at the same time, just talking to some folks locally, I don't think they're actually using this now.
Okay, does it remove judicial discretion?
Go ahead. It does. They cannot do 200 hours of community service for a DUI instead of the 48 hours. The statutes that we've passed here say that if you're convicted of a DUI first, you have to do 48 hours. That's what's true throughout the entire state. It seemed like it was something that was kind of just left over. I can't even figure out why it was in the statutes to begin with. It was in there several years ago.
Any other question for the sponsor? Representative Hardaway.
Thank you, Mr. Chairman, and to the leader. This doesn't make it doesn't exclude community service from the overall sentence, does it?
Good. No, sir, it does not. If the judge would like to do additional community service on top of the 48 hours, that's definitely a possibility and is encouraged in certain circumstances, but it just makes sure that that 48 hours is the same from Mountain City to Memphis. And I will say, I have found, at least in my almost 20 years of experience of being in criminal court, it makes an effect. I mean, when someone is a DUI first offender and they do 48 hours in jail, it gets their attention. It's not a lengthy enough jail time that it completely disrupts their life where they, lose a lease or a job or something else. But 48 hours in jail for someone who's never done jail time, and a lot of these folks that get a DUI first offense have never been in jail before, except for the night they may have been arrested. So when they're convicted and they do 48 hours in jail, it does reduce the recidivism rate. Now, we can have some long conversations about once you get beyond 30 days on the, on how jail time affects different folks. But for the 48 hours, it does seem to be very effective.
All right. Thank you, sir. Thank you, Chairman.
Any other questions? All right. Representative Towns. Question been called on the bill. That's just refreshing. All right, we're voting on 1444. All those in favor say aye.
Aye.
All opposed, no. Ayes have it. Moves to finance.
Thank you, Mr. Chairman, members of the committee.
That moves us to item number 9, House Bill 1459 by Chair Lady Moody. A motion and a second, and I'm showing an amendment. Is that correct?
I think so. And in committee, I'm going to tell you, it's a new amendment.
It is.
And I don't have it in my book. And I left my phone, so I can't call. I'll call a friend.
Well,
but
I'll just tell you what your amendment number is. It's 4553.
Thank you.
All right, we need to put this amendment on the bill. Motion. Second. We're voting on amendment 4553. All those in favor say aye. All opposed, no. Ayes have it. The amendment's on the bill. Go ahead and explain, please.
All right. What this will do, if an inmate, while incarcerated, commits a crime, the inmate will be tried for that offense, and sentence will be added on to the end of the current sentence. And we all know we have a huge shortage. I met with some of our state employees this morning, even, that pointed out that they have a 200 short of our corrections officers in the correction facilities. And this one also, of course, for those that are still in there, would be a deterrent likely against any felonies and misdemeanors being committed while in prison. So with that, it's the purpose of the bill.
Okay, thank you, Chair Lady. I would like to go out of session and have legal explain exactly what this amendment says that we put on. Okay, thank you.
Michelle Fogarty, Legal Services. The amendment requires the warden to report an offense to the District Attorney General within 5 days, and it lists certain offenses such as aggravated assault, first-degree murder, second-degree murder, voluntary manslaughter, criminally negligent homicide, aggravated rape, aggravated sexual battery, and indecent exposure. So an inmate commits any of those offenses while incarcerated, the warden will be required to report that to the district attorney. And then it'll be up to the district attorney to decide whether or not to prosecute. And then it also allows the judge to sentence them consecutively for that if they're convicted of that offense. Gives the judge the discretion to do a consecutive sentence.
Okay, any questions for legal on this amendment? Representative Johnson.
Thank you, Mr. Chairman. It puts indecent exposure on par with rape and murder. Did I hear that?
Legal.
Michelle Fogarty, yeah, indecent exposure is on the list of offenses that have to be reported to the district attorney.
Thank you.
Just to clarify, it's the indecent exposure committed with the intent to abuse, torment, harass, or embarrass a guard or a staff member in the correctional facility.
Okay, any question for legal? All right, we're back on the bill. Any questions for the sponsor? Vice Chair Gillespie.
Thank you, Mr. Chairman, and Chair Lady Moody, thank you. Just curious, without going into a whole lot of specifics, there have been a couple of cases recently in my neck of the woods where people have been released, whether it be early or on time, and during their time of incarceration, they have violated multiple of the rules and offenses that you just named. Is your opinion that this will allow them to either remain incarcerated longer if they keep on breaking those or committing those offenses?
Go ahead.
I believe it does, but if you need legal to confirm that.
I missed it.
No, I'm good. Thank you.
Thank you.
Okay, another question for the sponsor. Question being called on the bill. We're voting on House Bill 1459. All those in favor say aye. Aye. All opposed, no. The ayes have it. Chair Lady moves on to calendar and rules.
Thank you.
That moves us to item number 10, which is House Bill 1022. You have a motion and a second. Chairman Doggett, you're recognized.
Thank you, Mr. Chairman. I have Amendment Code 6145.
That's what I'm showing to motion. And a second on the amendment. We're voting on Amendment 6145. All those in favor say aye. Aye. All opposed, no. Ayes have it. Amendment 6145 goes on the bill. Chairman, you're recognized.
Thank you, Mr. Chairman. It requires, if a court issues a warrant for a defendant's failure to appear on a felony charge or an A or B misdemeanor, that they are placed on any available state or federal list, such as NCIC. It also requires the arresting officer or that agency to exercise due diligence in determining the existence of prior arrest or convictions after that person has been arrested, but prior to the determination of bail. And any of that information gathered is to be put in the defendant's case file.
Okay, you heard an explanation of the bill. I wanted to ask one question. Somebody had talked to me recently about this and said that if there is a failure to appear, then they're taken off the bill, and then the responsibility rests on the arresting agency to round them up. Is that correct?
If that person has not been entered in the NCIC, there's a 10-day window there that they have to be entered.
Okay. Any other questions for the sponsor on this bill? All right, we're voting on House Bill 1022. All those in favor say aye. Aye. All those opposed, no. Ayes have it. It moves on to calendar and rules.
Thank you.
That brings us to item number 11, which is House Bill 764 by Representative Davis. There's a motion and a second, and I'm showing a couple of, one amendment that we have to deal with first. It's Amendment 7360. Is there a motion and a second? Got a motion and a second on this amendment to put it on to House Bill 764. All those in favor say aye. Aye. All opposed, no. The ayes have it, that amendment goes on. Now, to the committee, I would like to ask you this. We have an untimely filed amendment, and I'm going to ask for a motion to consider it due to the fact this is our last meeting, unless you want to come back. Oh, we've got all kinds of emotion now. All right. We have a motion to consider with a second. All those in favor say aye. All opposed, no. Ayes have it. Now I need a motion to accept it. Is it a motion? And a second. This is amendment, let me get the right number for you, 7425. Leader Lambert.
Thank you, Mr. Chairman, and I don't want to step on your line, but if we could hear just an explanation from the sponsor of the amendment, since it's late filed, it's probably in our system, but I did want to just hear a description if Mr. Chairman, you wouldn't mind.
That is fine. Sponsor, go ahead.
Thank you, Mr. Chairman. Thank you, committee. And so essentially what the untimely filed amendment does is when we were drafting the amendment of 7360 that rewrites the bill, there was some information that was not properly entered, and so we wanted to correct that. One of those was with regard to the date, that it's 90 days, that becomes from July 1, that those community oversight boards or those public advisory review committees have 90 days to reconstitute a board if they have one, and or just to make sure that time frame was correct. And then also with regard to the executive director, that part of when we were creating the language that matched up with the TBI, I had them review it to make sure that the executive director has to be have a background check not only from the Tennessee Bureau but also the FBI. And so we wanted to make sure that language was standard language, that the FBI would accept that. And what happened was we left off one of the subsections with regard to the drug testing for that executive director. So this amendment puts back into that qualification of having a drug test for the executive director, and then also corrects that date of 90 days.
Any questions? Okay, we're going to vote on adopting Amendment 7425. All those in favor say aye. Aye. All opposed, no. The amendment goes on the bill. Is there further explanation that there is to explain your bill as amended now, please?
Thank you, Chairman, and thank you, committee. And so essentially what this bill does as amended, it helps to create standards for these police advisory review committees. By imposing these statewide standards, it allows for a municipal governing body to create a police advisory committee that is adopted upon an ordinance of 2/3 votes of that city council or municipality. The purpose of the committee is to strengthen the relationship between the citizens and law enforcement agencies to ensure a timely, fair, and objective review of citizens' complaints while protecting the individual rights of local law enforcement officers. The committee will make recommendations concerning citizen complaints to the head of law enforcement. The committees will consist of 7 members appointed by the mayor and with approval of that governing body. This bill ensures that community oversight boards operate under the same standards statewide, and it allows law enforcement to conduct an accurate, fair, and valid crime scene investigation without interference by outside boards. And with that, I stand ready for any questions.
All right, you heard an explanation of the bill. Are there questions for the sponsor? Representative Johnson.
Yes, thank you, Mr. Chairman. It's a community oversight board, and you want to eliminate oversight from other things. I think we should eliminate oversight from the state and let our locals manage this the way they see fit. I know that I'm pretty sure that this was initiated by Mayor Victor Ashe when there were some situations in Knoxville that were pretty intense, and it did a good job to de-escalate tensions. I think that this is working well, certainly in my city, and I don't see the need for the state to step in when, as far as the folks in my district are concerned, and my city, that this is working well, and I think that they would like to see it remain the way it is. And I don't think that we need to, as a state, be coming in and telling what our locals what to do. Thank you.
Okay, before you respond to that, I've got to take care of some business here that I need to, before we go any further. Without objection, I want to roll both of these amendments together into one amendment. Now, the second port of business is we have some folks to testify on this bill.
Well, Chairman, may I respond
Yeah,
first?
you can get ready, and we will begin your testimony after the response from the sponsor. Go ahead.
Thank you, Mr. Chairman. And to the representative, I greatly appreciate your comments because the language of this bill was actually adopted from Knoxville's Police Advisory Review Committee. And so I'm glad to think that you appreciate that it's operating well, because this is essentially the language from Knoxville, and we have grandfathered them in. So thank you for your comment. And Chairman, I'm ready for witness testimony now. Thank you.
All right.
Could I respond to that?
Yes, go ahead.
Okay, thank you. I appreciate you talking to the city on this. Thank you.
All right, we're going to go out of session for testimony. We're out of session. Jill Fidert, is that correct? Okay. You're Executive Director of Metro Nashville Community Oversight, is that correct? Welcome, and please make sure the red light's showing there, and please state your name for the record. You a little bit further down, we can't hear you, and you have 3 minutes, and then it's open for questions.
All right, well, thank you for allowing me to share my thoughts today. My name is Jill Fitchard. I am the Executive Director of the Nashville Community Oversight Board. I want to start with saying that HB 0764 moves forward to abolish community oversight boards and instead creates a police accountability review committee, and this will be a sad day for accountability in Tennessee. Many Tennesseans, especially those in Memphis, are still reeling in despair and are traumatized from the brutal killing of Tyree Nichols at the hands of Memphis Police Department. Knoxville and Nashville have not been exempt with similar types of police brutality, and if left without a separate entity with the authority to independently investigate these instances of police misconduct, the police will continue to police themselves, which only builds suspicion and distrust of law enforcement towards those charged with keeping us safe. For instance, a 76-year-old African-American woman filed a complaint with our agency because an officer pointed a gun in her face when she went to pick up her grandchild from a traffic accident. She stated, "I now do not trust the police." Consider those words and what it means to stand on both sides of them. I know firsthand that policing is an inherently difficult job. Policing in a community where people don't trust you makes that job even more challenging and dangerous. Transparency and accountability in policing does not just help the public, it also helps officers who get into the field for the right reasons and honor their uniforms with their conduct, and there are many of those. 134,000 plus Nashville residents voted to amend the Metro Charter by creating a community oversight board with investigatory authority. There's been some misleading and frankly disingenuous information spoken over the last few weeks. On March the 29th, during a committee to discuss Senate Bill 0591, Senator Briggs stated, "I then contacted," or actually he contacted me, Director Roush of the TBI. The senator continued saying that certain community members would rush down there, the TBI, when there's a police shooting, and they were coming under the police tape, they were contaminating the crime scene, and really interfering with the proper investigation by an outside force, which is the TBI. And essentially, at least Director Roush said, because this has never happened in Nashville, we emailed Director Roush on April 6th to get more information about the comment to determine when this occurred, where it happened, who are those involved, and what was the corrective actions. We have not heard from the director as of yet, and I believe that each of you should request more information about this allegation if you used it to make any determination on this proposed bill. If you do not vote no on this bill, your willingness to abolish community oversight boards and replace them with less accountability review committees will stand to erode trust between the public and police at a time when the need is to be focused on repairing it. Thank you for your time and consideration.
Okay, thank you. Any questions for our guest? Representative Hardaway.
Thank you, Mr. Chairman, and thank you, ma'am, for being here. Thank you for the work that you do. So the main difference between what's being proposed and what we have in existence now for the civilian oversight boards, what do you see?
Well, it takes away our authority to investigate individual complaints. We would have to take a complaint that comes in and directly, within 3 days, send it over to the police department's Office of Professional Accountability or Internal Affairs to do the investigation. We wouldn't be able to make a discipline recommendation. So that's a very big issue for Nashville because our board is set up as a hybrid model, which is, by the way, a best practice. Based on cities that have consent decrees, they have used that hybrid model to help their police departments move further in the work that they're doing so that they won't continue to be on a consent decree.
Representative?
Thank you. And I dare say that if we had stronger civilian oversight boards, that I would not be working with civilians and community leaders, clergy, other elected officials right now in Memphis as a consequence of the Tyree Nichols murder to have the U.S. Department of Justice come in and conduct a patterns of practice investigation. We probably would have had this, some sense of transparency that would have had this revealed, these problems revealed, not just many years ago, but many deaths and assaults ago. So I share your concern. And I urge my colleagues to vote no on this, and let's let the local folks determine how they want to handle unlawful policing issues. And there's no stronger deterrent, I would suggest, than civilian oversight that has a degree of autonomy and independence. Thank you, ma'am.
Thank you.
Any other questions for our guest? All right, seeing none, we're going to move back into session. Thank you, ma'am. Any other questions for the sponsor of the bill? Question's been called on the bill. We're voting on House Bill 764. All those in favor say aye.
Aye.
All opposed, no. The ayes have it.
Thank you,
Moves on
Chairman.
to
Thank you, committee.
finance. That brings us to item number 12. House Bill 689 by Representative Hardaway. I'm sorry. Representative Hardaway, you are recognized.
Thank you, Mr. Chairman.
Oh, got a second. We got a motion and a second. Go ahead, sir.
Thank you, Mr. Chairman. This act is known as the Representative Mike Carter Act. And we worked for years to try to make sure that for domestic violence, stalking, assault, sexual assaults, et cetera, that we did not create an environment where the alleged victim was essentially locked up in their house in jail, so to speak, trying to make sure that they didn't encounter the alleged perpetrator. And the best way that we found for that to happen was GPS monitoring. This bill doesn't get into all of the ins and outs of global position system, but it does require the responding officers to such a field encounter to provide information, a document that informs the alleged victim of the existence of the GPS monitoring and the requirement, if the judge so sees it, for that to become a part of the bail for the alleged perpetrator. We think this will, because those situations when the crime occurs, the alleged crime occurs, that there's so much confusion, so much chaos. we want to ensure that the victim has this information and can act on it. And the best way to do that is to put it in their hands so they can, when they are calmer later, that they can decide what they want to do to enhance their own protection through the criminal justice system. With that, once again, I'll ask for your support, and I thank Leader Lambert for his work in crafting this initially.
Okay, Leader Lambert.
Move previous question.
Previous question been called. We're voting on House Bill 689. All those in favor say aye. Aye. All opposed, no. Ayes have it, sir. It moves on to calendar and rules.
Thank you, members.
I need to yield the gavel to Vice Chairman Gillespie.
All right. Thank you, Mr. Chairman. Up next, number 13 on our calendar is House Bill 1476. And thank you. And it looks like we also have an amendment here, coded 7364. How would you like to proceed with that?
We'll put it on now.
All right. All those in favor of adding amendment? Oh, a motion second, please. All right. All those in favor of adding amendment 7364, say aye. Aye. All opposed? All right. The ayes have it. It is added. Mr. Chairman, you may continue.
Thank you, Vice Chairman. I appreciate that. This bill simply says that in Department of Corrections, for an inmate to receive sentencing credits, they have to complete a department-approved validated risk and needs assessment and participate in the programming that follows that in order to be eligible to earn sentencing credits. And that's what the bill says.
All right. Thank you, Mr. Chairman. Does anyone have any questions? All right. The question has been called. All those in favor of sending House Bill 1476 to Finance, say aye. Aye. All those opposed? All right. The ayes have it. Please, thank you so much.
Okay, that moves us back to, thank you, sir. That moves us back to the special calendar, House Bill 1029, and we're going to move that to the clerk's desk. Which brings us to the end of the calendar and finishes us up for this portion of the year. I want to recognize some folks. John Gleason here in the research analyst on my right. And Michelle Fogarty, the attorney for us on my left. They have raked my chestnuts out of the fire more than one occasion, I will just tell you. My legislative assistant, Grace Bonecutter, down here. Our clerks, Alexa Anze and Catherine Wathel. And our sergeant at arms, which needs a star, an extra star. You have done an excellent job, and I appreciate you very much. It was an honor to be with you for this session, and I appreciate all your effort and all your work. You've been consistent. You've been here. You've been faithful. You ask good questions. It's been a joy to work with you. Yes, Representative Howe. I'm sorry, Chairman Howe.
Thank you, Mr. Chairman. Another name we need to add to that list that you just read is Chairman Bud Hulsey.
Well, you're very kind.
I thoroughly enjoy being a member of this committee, and I think it's a gift that you have of wit and wisdom that just, and sometimes we discuss tense things up here, as we demonstrated about an hour ago. But your wit and wisdom keeps us moving and on track and lightens the load sometimes, and I appreciate you and what you do for this committee and for the people of Tennessee.
Thank you. That's very kind. Well, I'm sorry, I missed one. Leader Lambert.
Chairman, I don't think you can get out of here quite that easily. You have several names on the list, or at least you should. I just want to say, as a former chairman of this committee, you've done a mighty fine job. We all appreciate your leadership. And you did forget to thank your subcommittee chairman, who made sure that an enormous number of bills that would have caused you a whole lot of headache and work remained in subcommittee or did not progress to this committee. But other than that mild oversight on not bragging on the subcommittee chairman beside me, you've done a phenomenal job, and we all deeply appreciate your leadership. Thank you, Mr. Chairman.
Thank you. Thank you. I also appreciate Vice Chair Gillespie in your effort to pulling the weight here. Thank you. Chairman Doggett.
Thank you, Mr. Chairman, and it has been a great pleasure to serve with you and everyone else on this committee today, and I think we've worked really hard this year. And earlier today, Mr. Chairman, I had the great honor of being a part of the local full committee, and the chairman of that committee announced that he was taking the entire committee to lunch. And therefore, I thought maybe that you would, since lunch is covered, you would take us out to dinner.
Second. Do I hear a motion to adjourn? I've got to take my cousin back there and his two daughters to lunch. Maybe you all can just join us. Yes, Chair Lady Moody.
Thank you, and not to break the mood, but I thought my DA had left. And Mark Davidson, thank you for being here. And then, Mr. Chairman, I do want to take an opportunity to have the mic and remind the members that I know Chairman Halsey used me as his subject of many of his jokes. And it's because I know he loves me very much and I love him. Thank you for a great committee. Thank you.
Thank you. Vice Chair Gillespie.
Thank you, Mr. Chair. I just wanted to thank you as well. This is my first year of being on the committee, which I am so fortunate and glad to be a part, and shocked that I was named to be the vice chairman, but I have learned a lot from you, and I just wanted to say that on the record. Thank you.
Thank you. All right. Is there a motion to, Representative Hardaway?
Thank you, Mr. Chairman. You know better. You know, I've decided that I'm going to do a summer study with just you and I, and it's going to be designed for you to know and pronounce my name. Okay? But seriously, Mr. Chairman, this has been a well-run and deliberative body, and I've enjoyed every second that I've been here. I've learned a lot from you and my colleagues, and I appreciate that we've been able to craft legislation. I may not always agree, but I do know that it's received a fair hearing before we send it out into the community. So thank you for the work that you've done, sir, and thank you to my colleagues for the way that we've been able to do work on this committee.
Thank you, sir. All right, is there a motion to adjourn? We are adjourned subject to the recall of the chair. Thank you.